The issue of lawfulness is not a problem at all. Obviously, it was lawful because there are only two categories of persons in this country who enjoy immunity from criminal prosecution or from searches, in fact, from criminal processes. The president, vice president, the governors, deputy governors. That's all. Every other Nigerian is totally subjected to the full criminal weight of our law. So the situation had become an epidemic.
As it stands,
and I don't think NJC is established and has the capacity to deal with an epidemic of these proportions.
The NJC lacks the capability.
It doesn't have the capacity at all. It's supposed to deal with a normal thing. When 2 or 3 people have misconducted themselves, then the whole process of appointing a committee to hear the petitions and then make recommendations, all those things are for normalcy, not to deal with an epidemic which was rocking, in fact, which was going to bring the whole country down. Because if you shoot down, if you destroy democratic hopes that if a person goes into an election and the majority votes for him, he'll be declared a winner. Once you destroy that, we are aiming for civil war. We are aiming, people are going to get to power by guns rather than by votes. Thankfully, they've been released on their own self-recognition, which is very good. But as for the Nigerian Bar Association, they have no moral right to speak. It sounds very bad in their mouths to condemn and to criticize, because the members of the Nigerian Bar Association are the ones responsible for where we are today in judicial corruption and total corruption of our electoral system and the whole criminal administration system. Nigerian members of the Nigerian Bar Association, the senior ones, are the ones responsible for it. So it sounds very ill and very bad in their mouths to begin to protest and say things. They are the ones who carry billions of naira and millions of dollars to these poor judges. They are the ones who corrupted our judges. It's the lawyers who corrupted the judges.
Welcome back. It's our concluding moments now. Let's get Markwe in on this one as well. Markwe?
Yes, I was just wondering. I mean, he just got to the first aspect you asked Chamberlain when you asked about whether or not they were immune from criminal prosecution. It's one area that has not been tackled properly. Are you saying that the NJC must find them, of disorderly conduct first before any other government agency can intervene in the matter?
Yes, that's precisely what I'm saying, and I'm saying that is a necessary implication from the constitutional provision that the courts must be independent and impartial in their constitution. So constitution is not just that you set up a panel, it's also the things around that person that enable him to be independent. Now, if the person could, if you're dealing with the EFCC,
so can I give a quick instance?
You're free.
Oh. So, for instance, if a judge is caught, if a judge was driving roughly or badly, and he is caught by, say, any of the government agencies that regulate driving, and needs to be fined or must appear before, a set-up court, one of those mobile courts, for instance, are you saying that kind of matter must be reported to the NJC first before the courts, in that instance, can do their own jobs?
No, I'm talking about things that affect the fitness of a person, that question the way and manner he's going about his job as a judge. That's what I'm concerned with. I'm not saying if you beat up your wife as a judge, you shouldn't be taken before the magistrate. You don't have immunity for that. But when it comes to what you've done in your capacity as a judge, because you're being questioned for that has direct effect in your state of mind, on your state of mind in addressing yourself to that job. Now, if you feel that you cannot safely do that job, you cannot safely give judgment against a particular organ of state, because something like this could happen to you one way or the other. You could get arrested, somebody could write a petition and say that you were corrupt, and they could come in the night, dead of the night, and then you don't know, somebody could drop anything.
All right, part of the recommendations,
and they take you away.
Part of the suggestions out there before, so that they can have that meeting, some are suggesting that, look, what if the NJC and the quoted section 36, 3 and 6 make the court sessions, the proceedings, the judgments live? So if it's broadcast live, who knows? That may reduce some sort of tension.
That's what I've recommended. I said, look, the way things have gone, we cannot be concerned anymore about washing the dirty linens of the judiciary in the public. It's already in the public. In fact, I used a proverb. I said the masquerade has already been disrobed in the market square. So there's nothing left. The only thing that can save the judiciary now is the aphorism of the judiciary itself, that justice must not only be done, but must also be manifestly seen to have been done. Nigerians have been, the expectations have been hyped and all of that. So if you go and organize a secret inquiry somewhere, if you say we did not find anything against these judges, you're going to run.
I'm talking about court proceedings.
No, I'm not.
Election tribunal cases, broadcast live.
Oh, election, no, well, of course, no, well, that also could help. But court proceedings are in public. Anybody is free to go there and watch.
In addition to TV public now.
No, well, I wouldn't know whether the judges will want to become stars.
What's wrong with that?
Because when you're putting somebody like me now, I don't know whether the judges want to become TV stars and all that. They might not really want that. They might not want.
Is it about what they want or what helps society?
No,
helps judiciary?
A judge wants to do his work quietly. You understand what I'm saying? He wants to do his work quietly.
But it's not quiet anymore now.
So that's the point. Now, as for this, well, if you look at this thing, my worry is this. There are certain Nigerians are not asking questions that they ought to ask. For instance, let's start from the basic. There was one of these judges that they said they could not arrest because a lawyer, a governor intercepted the process, as it were. Said, we're talking about 2 million. Now, where's the judge? Has he been arrested? Is it until you go to somebody's house and you find money before the person can be arrested?
They're going to be charged to court.
No. Where is the judge? Nobody is saying anything about that anymore. You understand? Then all of them, you say you found money. Now, how come you went and you found money in 8 people
won't all
at the
this
same
be
time?
Answered when they are charged to court?
No.
Won't you see it in the charge sheet and then the prayers of the
point.
court?
Now, that's where
I didn't know usually included.
This is where we differ. I am saying that the NJC should first of all vet these allegations. Now, if there is something for the judge to answer, there's what we call prima facie case. If there's a prima facie, it's not for the NJC to resolve.
Okay,
Mr. Can say, you go and sort it out.
Well, anchor at that point, Mr. Chukwuemeka is a legal practitioner. Thank you for coming on this morning. And that's the show today. We'll keep tabs on that pending the time they come with that decision. And thereafter, thank you for watching. I'm Chamberlain Uso.
Many thanks. I'm Sulaiman Alede.
Right.
Okay.
Thank you. I'm Maokwe Ogun.